Hello, law students and legal practitioners. Today, we will analyze the case of Matalam versus Commission on Elections, GR number 123230, decided by the Supreme Court on April 18, 1997. Let's begin. Here are the legal doctrines of this case. In a pre-proclamation controversy, the Commission on Elections, COMELEC, and the boards of canvassers are generally limited to an examination of the election returns on their face. As long as the returns appear authentic, complete, and duly accomplished, they must be accorded prima facie validity and included in the canvass. The grounds for a pre-proclamation controversy are restrictive and exclusive, as enumerated in Section 243 of the Omnibus Election Code. Allegations of election fraud, terrorism, failure of election, or irregularities that require the presentation of evidence aliunde and technical examination are not proper grounds for a pre-proclamation controversy and must be ventilated in a regular election protest or in a petition to annul election results or declare a failure of elections. Even where election returns are claimed to be statistically improbable, their exclusion in a pre-proclamation controversy is justified only if the nullification of such returns would materially affect the results of the election. Absent such showing, the canvass and proclamation must proceed. Here are the relevant facts of this case. Petitioner Noruddin M. Matalam and private respondent Zakaria A. Kandau were rival candidates for governor of Maguindanao in the May 8, 1995 elections. During the canvassing of election returns from the municipalities of Datu Piang and Maganoy, petitioner objected to the authenticity of the election returns and certificates of canvass, alleging massive fraud and irregularities. In the two municipalities, petitioner was credited with only 3,641 votes, while respondent Kandau allegedly garnered 44,654 votes. Petitioner asserted that exclusion of the returns from these municipalities would overturn Kandau's province-wide lead. Petitioner raised several allegations, including, the vote counting in Datu Piang was disrupted by grenade explosions, election returns were allegedly prepared without proper counting, no election was allegedly conducted in Maganoy. Statements of votes showed zero or negligible votes for petitioner in many precincts, and some precincts reported votes exceeding the number of registered voters. Because the municipal and provincial boards of canvassers merely noted his objections and proceeded with the canvass, petitioner filed multiple pre-proclamation cases before the COMELEC seeking exclusion of the questioned returns. While these petitions were pending, the provincial board of canvassers proclaimed Kandau as governor. The proclamation was initially nullified by the COMELEC for lack of authority but was later reinstated after the COMELEC dismissed petitioner's cases and upheld the inclusion of the questioned returns. Petitioner's motions for reconsideration and for technical examination of voters' affidavits and lists, CE Forms 1 and 2, were also denied, prompting the present petition for certiorari. Issue 1. Whether the COMELEC may, in a pre-proclamation controversy, go beyond the face of election returns and investigate alleged election fraud and irregularities. No, COMELEC is generally limited to examining election returns on their face. Sections 241 and 243 of the Omnibus Election Code limit pre-proclamation controversies to defects that are apparent on the face of election returns. Jurisprudence consistently holds that COMELEC has no jurisdiction to pierce the veil of election returns in such cases when resolving issues that require full-blown evidence reception. Petitioner's allegations, such as failure to conduct elections, grenade disruptions, and falsification of voters' signatures, required extensive evidence aliunde and factual determination. These matters are outside the scope of pre-proclamation proceedings and properly belong to an election protest or annulment case. Issue 2. Whether a technical examination of voters' affidavits and lists, CE Forms 1 and 2, is proper in a pre-proclamation controversy. No. A technical examination is improper in a pre-proclamation case. Pre-proclamation controversies are intended to be summary in nature. Jurisprudence, e.g., Dimaporo v. COMELEC, Long v. COMELEC, expressly rejects technical examination in such proceedings, as this would unduly delay the canvass and proclamation. Ordering handwriting and fingerprint examinations would necessarily require full-blown proceedings inconsistent with the purpose of pre-proclamation remedies. Hence, the COMELEC properly denied petitioner's motion for technical examination. Issue 3. Whether the allegedly statistically improbable returns from Maganoy should be excluded. No, even assuming statistical improbability, exclusion is unwarranted. Under Section 243, d, of the Omnibus Election Code, Exclusion is justified only if the questioned returns would materially affect the standing of the candidates. Petitioner failed to demonstrate that exclusion of the Maganoy returns alone would change the election outcome. His own figures showed that both Maganoy and Datu Piang must be excluded for him to win, which goes beyond the permissible scope of pre-proclamation controversy. Issue 4. Whether COMELEC committed grave abuse of discretion in affirming the inclusion of the questioned election returns and reinstating respondents' proclamation. No grave abuse of discretion was committed. COMELEC's factual findings, supported by substantial evidence and made within its expertise, are accorded great respect and finality absent proof of arbitrariness or patent abuse. COMELEC found the election returns prima facie irregular, relying on official reports contradicting petitioner's allegations. The court found no reason to disturb these findings. Thank you for listening and happy learning. Please don't forget to subscribe to the Legal Shepherd PH YouTube channel and click the notification bell to stay updated on newly uploaded cases and jurisprudence. See you again for our next case discussions.